I do remember back when I was a baby lawyer and everyone was just up in arms about the fines under the GDPR. And that just looks low in comparison to the DSA, 6% of annual turnover and 7% under the AI Act. So the fines are huge. They're all separate. They can all apply sort of consecutive or concurrently. And in addition, we're seeing this trend towards extraterritoriality, as with the EAA, as with the AI Act. So the EU is well aware, I believe, as to the increasing burden of compliance on businesses. We heard earlier today a reference to the Draghi report. So this was a report produced by Mario Draghi. It came out last September, and he identified this growing body, this increasing complexity of regulation as a blocker to innovation and business in the EU and to EU competitiveness. So he recommended streamlining. So we saw the European Commission communication on implementation and simplification, very, just runs off the tongue very quickly. That came out this February. And that set out the aims towards removing unnecessary burdens in EU laws. And then, as was mentioned again earlier today, the proposal to simplify the GDPR for smaller companies, which focused really just on record keeping, but we're hoping that this may be expanded to other concepts in the future. And in the context of the data regulators, it's a similar position. So the EDPB work program last year and this year said that a key action was to produce common positions and guidance across regulations, as with the AI Act that we mentioned earlier. And in fact, at a recent meeting, I just saw this last week, they adopted a statement on simplification and saying that they will be looking towards producing more practical resources like checklists and templates to help businesses comply. From a sort of authority, at the authority regulator level, the European Data Protection Supervisors also suggested a digital clearinghouse to allow the regulators to align on positions and policy. But all of this, as you'll know, with any legislative process in the EU, will take time. So what does it mean for us now? So in terms of how we manage interplay between the EU laws, the first two examples are pretty obvious, but firstly, look out for your exceptions and your exemptions. Under the EAA, there is an exception for disproportionate burden. So it's where it would create a disproportionate burden on you to comply with the accessibility requirements. Then there are ways that you can sort of just comply to the extent that it doesn't do so. And similarly, under the Data Act, or under any other act, reading through the recitals, reading through the text of the act, looking for anything that explains what happens in the event of inconsistency. Although, as we've seen in the EAA, sometimes it just doesn't say anything about that. So what else can you do? You can look at explanatory notes, legislators' intentions. I mean, it's easy for me to say that I'm a knowledge lawyer and I have the time to do so. This isn't always easy for you to do all this research. I understand that. What else can you look at? So the principle of lex specialis. So as you'll see for the example of, say, the e-privacy directive and the GDPR, lex specialis, a special law to the extent it covers a certain matter in question, and in the event of inconsistency, will take precedence over the more general law. And I think it's important sometimes to take a step back and consider the spirit and purpose behind why a particular EU law was drafted. I'm not saying there's no hierarchy between laws or between a regulation or a directive, but it's important to understand, a regulation has been drafted to be directly applicable. It is a clear statement of the legislator's intentions. It's not subject to debate or interpretation by member state. A directive, if you see the way it's drafted, is slightly different. It's more about presenting goals, objectives, the spirit of what the text is trying to say, and then it's ultimately up to the member state to transpose it domestically.